welcome everybody to the webinar. My name is Vince Sliwoski. I'm a business commercial real estate lawyer here in Portland at the office of Harris Bricken. I worked in heavily regulated industries for maybe 10 or 12 years. I publish our law firm Psychedelics Law Blog, which you may have encountered in registering for this webinar or elsewhere. I'm really pleased to be joined by and introduce a couple of eminent guests in this field. Angela Allbee is the Psilocybin Services Center Manager at the Oregon Health Authority, and she serves as the ex officio director of the Oregon Psilocybin Advisory Board. She's helped shape legislative policy in Oregon for nearly a decade in different things, and she's going to help us understand better about the structure of Measure 109, but also the current status and process of OHA rulemaking and sort of additional considerations as the program moves forward for potential licensees. The other speaker today is Mason Marks, Dr. Mason Marks. He's a lawyer of counsel with our firm. He chaired the licensing subcommittee. He recently stepped down from that, but he was a governor-appointed member of the board. He also founded the Project on Psychedelics Law and Regulation at the Petrie-Flom Center at Harvard Law School. And he advises on psilocybin and psychedelics legalization and decrim efforts around the country. Mason's going to help us discuss recommendations made by the board and by his committee and just sort of the overall direction of the Oregon program and maybe even some broader concerns. So really excited to start. I'm going to kind of hand it over right away to Angela to start talking about Measure 109. If you could give us kind of a structure and an overview, we'd appreciate it, Angela. And if I missed anything in your introductions, feel free to fill in.
Thanks, Vince, and hello, everyone. It's an honor to be here today to talk with you. Before I begin, I just wanted to mention that I work for the Oregon Health Authority, which is a state agency. We're directed by the language of Measure 109 to implement all of this work. And so if you have questions about the development of the language in the measure or the campaign that worked to pass the measure, I wouldn't be able to answer those questions. That wasn't a part of our work, but we're very excited to talk today just a little bit about the framing of the measure and then some of our work as our team begins to develop and as we begin to organize all of this work and continue to go through rulemaking. So to begin, I just want to introduce that this measure, the Oregon Psilocybin Services Act, is now codified in statute in ORS 475A. And so I just wanted to share that with you. It's housed within the Oregon Health Authority Public Health Division Center for Health Protection. And you might wonder why that's important. And I think it's important to understand the mission of our agency, and that is ensuring that all people and communities can achieve optimal physical, mental, and social well-being through partnerships, prevention, and access to quality, affordable healthcare. We are located under the umbrella of prevention and wellness, and we are part of the Center for Health Protection, which has a lot of regulatory work in it. We learned a lot after COVID and responding to COVID, as well as historic wildfire seasons and other issues that came up over the past few years. And so the agency understood that we had to change the way that we do business. And we are a centering community. We have a very intense and ambitious strategic plan goal to eliminate health inequities by 2030. What that does is gives us a framework for how we do our work, and that includes all bodies of our work. The next thing I just want to mention is as we talk about Measure 109 and talk about the implementation, it's important to understand that we're also guided at OHA by the strategic plan and the Healthier Together Oregon, which is the state health improvement plan. If you want to get to know more about that, you're welcome to look it up. It's an exciting body of work. What I will mention is that there are 5 priorities. That's institutional bias, adversity, trauma, and toxic stress, economic drivers of health, behavioral health, and access to equitable preventative health care. So I just wanted to mention that as I talk about our work as OHA makes decisions, broad making authority for public health and safety issues. Those are important factors in how our work is guided and how we make decisions. Our section is divided into 3 programs. We have policy and engagement, our licensing program, and our compliance program. I'll get into our roles a little bit later. Measure 109 creates the Oregon Psilocybin Advisory Board, which is a governor-appointed body of professionals and people with lived experience as well that advise OHA and provide recommendations. There's also some requirements for developing long-term strategic planning to ensure that psilocybin services will remain a safe and effective and affordable option for adults 21 years of age or older. They're also charged with monitoring and studying federal laws. And so we look forward to continue working with the board. They were appointed in March and began organizing into their 5 subcommittees and really doing a lot of intensive work with, which I think Mason is going to talk about more in a little bit, to really frame up the recommendations that will come to OHA, and some have already. Measure 109 creates a regulatory framework for the licensing and compliance work that we're going to do, which is the production of psilocybin and provision of psilocybin services. It does not create a dispensary model that maybe everyone's familiar with in cannabis, and it's not a medical or clinical model. It doesn't require a referral or a prescription from a doctor or a provider. So we'll talk a little bit more about that in a bit. There are 4 licensure types, and if you want to get more in the details, you're welcome to look on our website, read the measure, or reach out to our team and we'll help provide some more information. But the first is a manufacturer license, and this license is for folks who are cultivating and processing psilocybin and psilocybin products. It's only for indoor cultivation, and there's a number of other statutory requirements associated with this license that I won't get into just because of time. But it's important to note that there will be a defined premise for manufacturers and then for another license type that I'll talk about in a minute. We do have to set production limits for psilocybin products. And so that's something that our team will be working on and really looking at closely as we develop out this work and start accepting applications for licensure on January 2nd of 2023. The next license type is a testing lab license. Testing labs will, test products specifically as we adopt final rules that will kind of lay out what that is. But all testing labs prior to licensure have to be accredited by the Oregon Environmental Laboratory Accreditation Program. And we'll talk a little bit about where we're at with expedited rules for that body of work. We have the service center license, which is a really important license type because this is the only premise where psilocybin can be sold to a client and consumed by a client only during an administration session. And so I'll talk a little bit more about that, but I think there's a number of considerations for this actual license type, and we can talk more about that in the local licensing piece or the local government piece. There's a facilitator license, and facilitators have to complete an OHA approved training program in order to apply for licensure, and they have to be an Oregon resident for 2 years. That does expire in 2025, but it is important to note that this particular license type will have to undergo this training program. Before I kind of move further into what psilocybin services are, it's just important to note that OHA has already worked with the board on expediting a subset of rules to address some of these levers that need to be put into place that affect, sort of the ongoing work that we have to do and make sure that all of these pieces are complementary. So training programs, which anyone that applies for a facilitator license has to go through and graduate from, we started working on that subset of rules along with the products and testing in order to set the criteria for accreditation by ORLAP, which I mentioned earlier. This subset of rules, we got recommendations from the advisory board, we drafted proposed rules and made some decisions, and then we set up rulemaking advisory committees that met and discussed these rules in February. We're currently in a public comment period for that subset of rules, which will end on April 22nd. We will have a number of public hearings that will have Spanish interpretation, American Sign Language interpretation, and cart captioning. And we invite folks to join us for those. And I'm happy to share those dates a little bit later, but you can also find them on our website. What's important to note is this expedited set of rules is something that we'll be finalizing and adopting in the middle of May. so that we can start accepting applications from training programs on around June 1st of this year. That will give training programs plenty of time to go through the admission process after they're approved and start accepting students, start training students, and then those testing labs can really work with ORLAP on accreditation criteria. So the board will have until June 30th of this year to provide all of the remaining recommendations so that we can set up the remainder of the rules and draft proposed rules in time to do some rulemaking in September. I'll talk more about that in a little bit. But another really important body of work that Measure 109 requires is product tracking. And I think you're all pretty familiar in the cannabis world with the metric tracking system, which is seed to sale. We'll have a system for product tracking that is spore to sale. And we're working currently now on setting that up, and I can talk more about that if anyone's interested. I think it's important to note that Measure 109 encourages us and requires us to prevent diversion into the unregulated market, and it's really important that we're looking at that and finding ways to really customize and develop a strong tracking system for those products. Another consideration about Measure 109 is local government issues. Local governments do have the authority to adopt ordinances to prohibit manufacturers and service centers from operating. Those ordinances do have to be passed in the next general election, but that is something to consider if you're all interested in setting up a business and being licensed by OHA to do this work. Another thing that local governments have the authority to do is really adopt time, place, and manner regulations. And then land use compatibility statements will be required for those manufacturers and service centers that are licensed. So that's something really important to keep in mind. We have been working closely to try to develop some conversations with local governments, and we'll be continuing to do that from the state level to make sure that we've got a clear line of communication and more information to bring to all of our partners and future regulatory community members, as well as members of the public. It's important to note that there are license and application fees that will be a really important part of making sure that this work is sustainable. We are a fee-based program, so the cost of administering all of this work has to be covered by license and application fees. We don't have the authority to regulate the cost of psilocybin products or services, but we do charge the license and application fees. There will also be a 15% retail tax on the products that are sold to clients, and those funds, that revenue will have to go to the Department of Revenue, and then will come back to the Oregon Health Authority after they've taken their administrative cost from that revenue. A couple of quick reminders is that we are still in a development period for Measure 109 implementation. That began January 1st of 2021 and runs until December 31st of this year, the end of 2022. We did also reach a milestone in publishing our rapid evidence review, the scientific literature review that the board worked on. That was published in July of last year. The board will continue to do additional work to look at the cultural and anthropological components that were not addressed in the scientific literature review. The board has until June 30th to submit their recommendations to OHA, and then we have until December 31st of this year to adopt rules just in time to accept applications for licensure January 2nd of 2023. I'm going to just make a quick note about psilocybin services. Psilocybin services may include a preparation session for clients. That's when a facilitator and a client meet together to discuss psilocybin services, go through potentially the client intake form and informed consent, and really walk through if it's a good fit. Then they'll schedule an administration session at a licensed service center, and that's when the actual consumption of psilocybin will take place. And then there will be an optional integration session. It's important to note that we have not yet drafted these proposed set of rules, so we're waiting for the board recommendations to come to us by June 30th, and then we'll be developing those proposed rules and going through rulemaking this fall. I'm going to stop there because I know that Mason has some great information to share and will walk us a little bit more into some details, and so I'll come back later and talk a little bit about our rules as well.
Before we go to Mason, Angela, I get asked this question all the time, and you're probably the best person to answer it. You kind of march through your timelines and dates and stuff. People constantly say, is it going to be on time? Are rules going to be issued, final rules in December, and are applications going to be submittable in early January? Do you feel like OHA is on course at this point?
Absolutely. We are on track. In fact, the fact that we'll be accepting the training program applications in June means that we've done a lot of work to push our timeline up in that regard. Also, because we expedited that rule set, we've had to prioritize all of those discussions around training programs and then some of the products and testing rules. I'll talk a little bit more when we speak about our role, but we have a lot of work that goes on internally when we go to set up and implement this work. And so a little later, I'll get into that and explain what some of that work looks like. But we are on track, and I'll provide a little more context later. Great question.
Cool. Well, maybe Mason can tell us some about his committee's work and just thoughts on the license types and the recommendations so far generally.
Thanks, Vince, and thanks, Angie. Yeah, I think before I get started, I'll just say I work with a lot of organizations, and what I'm about to say is entirely my own personal opinion and does not reflect the opinion of any of those organizations or any government agencies for that matter. But I think I will walk you through some of the recommendations that have been approved by the licensing subcommittee in the past year, and they kind of cover a wide range of different facets of the emerging industry. And I will emphasize that these recommendations have only been approved by the licensing subcommittee. They have not yet been considered by the full board, but they will be considered and voted on in the next few full board meetings over the next few months before the end of June. And also just want to kind of say, like, this really is a historic moment to have these rules for consideration. It's really quite exciting to see this industry come together. There's been a lot of hard work over the past year. There are a lot of great things in the rules. There's still a lot of unfinished work, some unresolved issues, and that's kind of what I want to focus on a little bit now. And these things will be considered, but so far they haven't really been discussed. And one of those things is the licensing exam that all facilitators will have to take. So we know that there will be an exam that every facilitator candidate will take upon completion of their respective training programs, and that will be administered by the training program itself. So they'll design that exam and administer it to the candidates, and that is referenced in the current draft of the rules. But there will be a standardized test for all facilitators that they will take regardless of what program they completed their training through. And I think that's really important because for many people, this program and the concept of a facilitator have created a new type of profession, the psilocybin facilitator, and you want that profession to have standards and ethics, and that's why it's important that we have a standardized way of assessing their skills and knowledge. And I think there has been a little bit of concern raised that if the training programs themselves are responsible for testing alone, they're incentivized to pass their students, or they might have some unhappy students asking for their money back. You want a way that's above that, a robust way of testing their knowledge. So I'll just go through a few of the recommendations. The first is that this licensing exam be a multiple choice exam that evaluates knowledge and concepts from the training curriculum, the text of Measure 109. So there will be some legal knowledge that candidates will be required to know if this is adopted. Documents produced by the licensing subcommittee, which include things like a facilitator code of conduct and an informed consent document that, if adopted, would be administered to all clients in the program, and as well as rules adopted by OHA. So candidates will have to be knowledgeable and conversant in both the statute and the administrative rules. And then another recommendation is that this exam be developed internally and maintained internally by OHA and the Psilocybin Advisory Board with input from the licensing subcommittee. And outside experts could be consulted as needed, but that arose because at one point there was discussion of having some groups or organizations outside of Oregon take responsibility for that exam, and there was some concern that it might not be tailored to the needs of Oregon, and so that's why that was made. It's been recommended that candidates be allowed to take the licensing exam at home using remote proctoring software, but because there are some concerns with privacy invasions with that software, the software needs to protect candidate privacy, as well as being accessible to people with disabilities. And then if people don't pass the licensing exam, under this recommendation, they'd be able to retake it after 6 weeks of receiving the non-passing score. And the exam should be offered in multiple languages and in alternate formats to ensure that it's accessible for people with disabilities. And then the cost of that exam, it's been recommended that it be no higher than need be to maintain the testing program. So that's pretty much the testing in a nutshell. There have been some recommendations made around product labels. Psilocybin product labels should be reviewed by OHA before the products are offered for sale. That's something that is required in some cannabis jurisdictions around the country. And the ingredients of those products, as well as a lot of other information like the dosage, any solvents used in their production, and common allergens, specifically should be listed in bold. And I think that's an important concern because the last thing you want is someone having an allergic reaction in the middle of a psychedelic experience where they're not really going to be in touch with their own sensations. You know, people with allergies, they know when they're having an allergic reaction. They might not know that if they are under the influence of psilocybin. It just occurred to me in thinking about this morning that there might be some rules that should be incorporated as well with respect to allergens for the manufacturing facilities, and there also could be, you know, in terms of segregating out common allergens like peanuts and things like that. And there could also be something added to the label regarding whether the products are made on shared equipment with allergens and things like that you typically see on food products. And then something interesting here is that it's been recommended that clients receive an easy to read information sheet prior to the start of the administration session that lists all of those ingredients. So they, you know, they wouldn't be required to kind of squint their eyes and look at a product packaging because they might not be permitted to handle that packaging. That way the facilitator can hand them a sheet that has all that information, you know, maybe in large font that's very easy to read. I mentioned briefly this facilitator code of conduct. That's something that was approved back in January by the licensing subcommittee. And I won't go too much into that right now. A few other just sort of miscellaneous recommendations include group facilitation. So it's been recommended not only that administration sessions be conducted in groups to bring the cost down and make things more accessible for people, but also the preparation and integration sessions. And those sessions in particular, unlike the administration sessions, could be offered remotely for people who it might be burdensome to travel somewhere if they're in a remote area, for example, or for people with disabilities again. And there have been recommendations regarding the maximum client to facilitator ratio with respect to groups. The recommendation made by the subcommittee was 8-to-1, so that would be 8 clients for every facilitator. And a slightly different recommendation was made where subperceptual doses are consumed. So that would be what you might call a microdose. And the recommendation there was slightly higher of 10 clients to each facilitator. And then there were some recommendations made regarding online training. I'll talk about the rules in a bit more detail a little bit later. But for now, especially because we're living in sort of this I don't want to say post-COVID world, but this COVID world where most people are working remotely, and we've learned that a lot of things can be done effectively that way. There's been a recommendation to allow the core training. There's right now 120 hours of core training required by the rules, and at least 25% of that needs to be done in person. And so the licensing subcommittee had recommended that all of that training be allowed to be conducted in person. The practicum training is a different story. That's where people are actually working with clients directly. Core training is more of a kind of what you might think of as traditional classroom training. And there's also a requirement in the current rules that whatever is offered online, and you could have up to 90 hours online of the 120, the current rules say that 50% of that must be done synchronously, where the instructor is speaking live to all of the students. But OHA has heard from a lot of members of the public as well as board members that even requiring synchronous learning could pose a barrier for a lot of people. A lot of people, they work irregular hours. If you work at night and sleep during the day, or you have childcare obligations, you might not be able to make a regularly scheduled class. And some people report that they learn better asynchronously when they have time to rewatch portions of a lecture, or they can go at their own pace and so forth. So the recommendation there was to allow things to be done synchronously or asynchronously. Moving to the administration session, an important question has been, how many facilitators do you need in the room during an administration session? And there are medical programs where 2 facilitators are required at all times. That has not been the recommendation from the licensing subcommittee, which has suggested that 1 facilitator be present at all times, with the exception of short breaks for restroom breaks or breaks to get something to eat or drink, because these sessions can be quite long. But when the facilitator leaves the room, they are not to leave the premises, and another staff member of the service center needs to observe the client. That staff member need not be a licensed facilitator, but they could be. And so you could have more than one, but under this recommendation, it would not be necessary. A really interesting recommendation is the idea of variable length administration sessions. So if we look at the text of Measure 109, there's nothing in the measure that says how long an administration session should last, and it is up to the health authority to determine what when a administration session concludes. And psilocybin can remain active or have an influence over people to a significant degree for hours, for 5-6 hours. And so some sessions may need to be that long. In other cases, they might not be. If a person is given a very small test dose, for example, just to see how they react to the substance, if they're worried that they might have an unpleasant experience, or they just have some anxiety, or maybe they're worried they might have an allergy and they just want to take a small dose, then perhaps the session could be significantly shorter, maybe an hour, or depending on the circumstances, different increments. And so the recommendation was that it really lie with the facilitator to decide when the administration session ends, based on a variety of factors, such as the type of psilocybin products administered, the goals of the client, whether the client has a reliable means of being taken home, and the degree to which the product is affecting the client physically and cognitively. So if the person took a small dose and the facilitator judges that it's really not affecting the client, they could leave after a shorter period of time. And that will help bring the cost down, because you're not requiring people to pay for 5 or 6 hours when it's not necessary. Another recommendation is about how long clients can be made to stay at the center if they want to leave. It was discussed extensively and decided that we don't want facilitators forcibly restraining clients who are trying to leave. That's a recipe for some pretty bad situations. And so the idea is that clients may leave a session before it's concluded, but the facilitator needs to advise the client that they're leaving before its conclusion, and they have to record that information that the client left against the advice of the facilitator. And I think I'll leave that there. Well, probably one of the last things I'll mention, at least right now, is advertising. There are a lot of rules regarding how companies and dispensaries can advertise cannabis, and so we'll have similar types of rules in Oregon. And the recommendation was that the OHA not prohibit product advertising. That was something that is sort of mentioned in Measure 109. It's not explicitly prohibited, but arguably OHA could impose some regulations there. But it was felt that it would be important for the public to know what products are available. For example, if you're a person who does have a disability, you might need a specially formulated type of product, and you arguably have a right to receive that information. And there are a few other details. OHA shall prohibit advertising that violates or promotes breaches of the facilitator's code of professional conduct. OHA shall allow advertising that presents scientific data on the safety risks or effects of psilocybin. The reason that's in there is there was some concern about companies or service centers making medical claims. And Angela mentioned that Metro 109 is not a medical system. We wouldn't want facilitators making claims regarding diagnosis and treatment, but you would want them to be able to convey factual information, scientific data, and safety information, etc. So I think that is kind of a pretty decent overview that might, stimulate some questions and thought. And I encourage people to post questions that we can address. But thanks again for having me. It's great to be with you, Vince.
Yeah, well, let's go back over to Angela then. Angela, and thanks for a great summary, by the way, Mason. Angela is going to talk a little bit more about the program from the OHA perspective. What did you leave off that you'd still like to cover?
Thanks, Vince. Yeah, and thank you, Mason, for that overview. I think first of all, I'd like to mention, talk a little bit about our role, some of the work that we've been doing as a section, and then talk about our timeline going forward and ways that all of you who are listening in can engage on this work. As we all know, it's first in the nation to set up this regulatory framework, and there are lots of people paying attention. So it's really important that we're, hearing from our communities, hearing from everyone, and really understanding perspective. So I guess I'll start with talking a little bit more about our team and the work we're doing. And this sort of ties to, Vince, your earlier question about, are we on time, on track for this work? Some of the work that maybe is a little bit less interesting, but very important, is the internal development of our systems in order to make this work happen. And so our team, which we are now a mighty 6 people, we have 6 team members right now, but we're really looking forward to developing our licensing and compliance program teams out very soon. But we are in the process of working on many tasks. One of those is that we have to establish rules by the end of the year and work really closely with supporting the Oregon Psilocybin Advisory Board and subcommittees. And so all of that work is really, really important, obviously, for the development of our rules and kind of looking ahead and moving forward. We're developing a sort of facilitator training program approval system. That's a long way of saying we're actually developing and working closely with our partners internally to develop a system that people can access and apply to have their training program curriculum approved by OHA. It's important to note that OHA does not have the statutory authority to regulate training programs. We can only approve their training program curriculum. And so it's really important to mention that as you know, it's a very different body of work than the licensing and compliance work that we'll be doing as we start accepting applications in January of 2023. We're also developing our license tracking and compliance case management system. This will similarly be a way for people to go online and apply, and then for us to do our compliance case management work. We will also allow opportunities for other, like paper applications and other formats for people that, have accessibility needs that are different than online or may not have access to the internet or to computers. So we will be also developing all of those forms. We're working on securing and customizing the product tracking system that we discussed. And while there's many similarities with cannabis, there's also a lot of differences when we talk about fungi. So, we have to develop and customize all of this work. We are working on that contracting process right now, and we'll have more information for everyone who's interested very soon. We're working on establishing, our work with online payment systems. We're setting up our fund internally, and so that way funds can come in, application fees, licensing fees, the revenue from the tax can all come into the fund. And that's also an important and interesting body of work. We have GIS mapping that we're looking at really building. We have to make sure that we're tracking proximity to schools for the manufacturers and service centers. They can't be within 1,000 feet of a school, and there's some more details and nuances to that, but ultimately we want to make sure that we're building a footprint and can better understand both school proximity, but also local jurisdictions. Like anytime there's a prohibition or certain zoning restrictions, that we have the ability to map that out as well. We're working on an equity and justice centered approach to background checks, ensuring that we're really looking ahead at what we've learned from the body of work with background checks and traditional healthcare workers. There are certain stipulations in statute about the way we do background checks, and so that's an interesting body of work. We're continuing to hire and build out our teams for the license and compliance programs. We have the 2 managers in place now in their roles, and they'll be working on setting policy and procedure based on rule for those 2 programs. We're building our website continuously and trying to get information out to interested folks, partners, members of the public, and future regulatory community members. We're also really trying to build relationships and partnerships with communities around the state to really understand what their needs are and to help them understand our process and how to engage with us. We also are trying to create an education and training sort of resources and tools for our regulatory community. We'll have to start, once we adopt rules, really start working on training and making information available. We're also partnering with many partners and state agencies to work on creating a forum or an event for future regulatory community members. Since we're not a business-centered agency, we're a health-centered agency, we want to provide information and tools and to folks that are going to start a business, especially small business owners, so they know who to go to for technical assistance and support and what's available. Because psilocybin is still a Schedule 1, meaning that it's federally illegal under the Controlled Substances Act. There are very limited ways that folks can get grant funds and opportunities to start up businesses, and we also want them to understand more about insurance, banking, security issues, and also the 280E process. And we are not the experts on all of that, but we want to bring in the resources to help everyone. So we're working on that, and obviously, I've talked a little bit about our expedited subset of rules that we're working on right now. We hope to have those adopted as final in the middle of May. And then again, we'll send some announcements out about training programs and starting to accept those applications for curriculum approval. We'll also be receiving those recommendations from the Psilocybin Advisory Board, which Mason mentioned, some of the great work that the licensing subcommittee has done. All of those recommendations will be considered by the Psilocybin Advisory Board, and then those recommendations will come to the Oregon Health Authority. We will draft our proposed rules for that, for the remainder of the rules for this work, and then we'll build rulemaking advisory committee tables where we'll get a pretty diverse perspective to discuss these rules and provide additional insight and feedback, and then open that up for public comment. And all of that will begin this fall, just in time for us to adopt those rules as final by the end of December of this year. We will have a couple of public hearings. I encourage all of you to look on our website. We will have 2 public hearings, one on April 18th from 5 to 7 p.m. Pacific Daylight Time, and one on April 21st from 10 to noon Pacific Daylight Time. And all of the information is on our website. And if you do have other questions, please feel free to reach out to us. We also encourage all of you to stay connected to us by signing up for our distribution list. And we will also be posting job announcements. So if you're interested in being a part of those licensing and compliance programs, that'll be important to pay attention to those announcements that come out. We're also kind of finalizing some quarterly newsletter to share information and feedback. I think all of you might be aware that we did a community interest survey recently to really gauge interest in the 4 licensure types, as well as who has training programs that they'd like their curriculum to be approved by OHA, and then overall who's interested in accessing services. One thing to note is from that community interest survey report and all of those findings is that we really see the need to do really intensive outreach to communities of color and to ensure that we're hearing from diverse perspectives around the state. And so we're really working to engage with partners. It's a part of OHA's work, and it's now being incredibly clear, even more clear with that community interest survey, that we have more work to do. And so I just wanted to mention those few things. I'm happy to answer any questions, and I know that I'm going to send it back over to Mason to talk a little bit more, but I'm not sure if Vince or Mason, you have anything else you think I should highlight.
Well, it's tough because we've got limited time, and we also have a lot of questions coming in. Some are sort of interesting, and we haven't touched on them that much. Maybe Mason could talk about because you were just talking about rules. Maybe Mason could talk about what he thinks could be improved in the rules, or what rules, suggestions he likes or doesn't like. Would that be a good thing to cover at this point, Mason?
Sure. I mean, one thing that I just kind of picked up on that Angela mentioned was that this current version of the rules is intended to be finalized in May. And that kind of gets at a question that somebody asked, I noticed in the chat, about a little bit of a concern. Shouldn't these rules be finalized after the facilitator rules are finalized? Because it seems like a lot of these rules regarding training and other things will be affected by those recommendations. And so I guess it's I'm a little unclear on if those rules, the current rules that we have, if those are finalized in May, will they continue to be reworked until December, which is when the statutory deadline is, or is OHA kind of drawing a line in the sand saying no, after May, that's it on those rules, which does seem to pose a little bit of a problem there. But to dig into some of the rules specifically, there were a couple really positive changes. I think one positive change that I just want to highlight, which I think is really great, is the following. There was a recommendation out of the licensing subcommittee. Well, first of all, just to focus on training. There had been recommendations that there be partial training programs that offer different modules of the curriculum. And the idea there was to create a competitive market for training programs, and people could complete part of a program at their convenience and complete the rest later when they have the money or they're able to. But the OHA has chosen to require all programs to offer every module, which I think is a bit of an accessibility concern, because the programs might be more expensive and more restrictive. People can't complete them on their own time frame. And also, presumably, because all programs have to offer practicum training, and practicum centers have to be licensed service centers. They either have to be a licensed service center or they have to contract with a licensed service center to offer that practicum training, which could be prohibitively expensive for some training programs. I mean, I guess the first, I'll get to the good change that I saw, but I guess one kind of criticism is that we really should see those partial training programs to make things more affordable and allow more people to start training programs. But a positive thing, there was a recommendation that training programs be able to offer alternatives to the practicum. The idea of the practicum is you actually go observe and participate administering psilocybin with real clients. But that might not always be possible if someone's in a rural part of the state, or the current rules say a training program can be anywhere in the country. So if you're in Massachusetts with a training program, it's not really practical to send your students all the way across the country to an Oregon service center. So a recommendation was made by the licensing subcommittee that training programs be able to allow alternatives like simulations, role playing, perhaps using other substances or means of mimicking the psilocybin experience. And I am happy to see something like that included in the current incarnation of the rules. It says that if a practicum site is not reasonably available or accessible to students, a training program may identify alternative practicum in their application for approval that reasonably approximates training at a practicum site. I guess the question is, what qualifies as reasonably available or accessible to students? Is a cost a problem? Would that be viewed to be reasonably inaccessible? If it's too expensive for the program to afford? Is location considered? And the training program has to explain what kind of an alternate it's going to include in its application to OHA. So I guess, on what basis, what criteria would OHA be using to make those approval decisions? Another thing worth raising is the restriction to Psilocybe cubensis, that single variation of the fungus. So the psilocybin, all the products have to come from that single variation. And as many people know, there are hundreds of varieties of fungi that produce psilocybin, many of which are used by indigenous communities or in other countries. In the Netherlands, for example, people can purchase many varieties of these fungi. There are no safety concerns that have been identified by the Dutch government, which commissioned a scientific study to look into that. And so there really is no legitimate safety reason to restrict to a single variety. There might be reasons to not allow a small number of varieties, but I think the reason that's a problem is that we know from cannabis that different strains have different effects for people. If they have insomnia, they might want one strain. Another strain might be a horrible problem for them if they're trying to sleep at night. And so the same is likely true. I've heard that it's true. I don't know that different varieties of psilocybin fungi could have similar effects. And so there might be people who don't get a benefit from cubensis. And so from the sake of providing benefit to people, as well as from a business perspective and the opportunity it's created through innovation and competition, I think that's kind of an issue. I think I'll just leave it at that for now, just to make time for more questions.
Yeah, I might, just because we're limited, we have 10 minutes, and I want to talk a little bit about businessy stuff. It's important, and a lot of people ask questions around that in the lead up. I'm going to get into that. We'll see how much damage I can do here in about 10 minutes, probably not a lot. I think this will be kind of an issue spotting exercise, just touching on some high level stuff. And I've written a series of posts on this on our psychedelics law blog, by the way, so better information there than I'm about to give you. But and I think I wrote 3 of those and took a break. I'll probably write a few more of those coming up. I guess I would say, to start, in my mind, all of these issues tie back in one way or another to the fact that we're dealing with a Schedule I controlled substance federally, like Angela said. The status of psilocybin is going to kind of ripple through the administrative program rules as we're seeing, but also through business in general, with respect to every single contract you ever sign in this industry, or just basic business realities on things from banking to intellectual property, to income tax, everything. So I think the first thing I want to highlight for everybody, because I'm a little surprised how often this catches people off guard, is that there are restrictions on ownership in the program. And they really come in two forms when you break it down. The first is a residency requirement, and the second is other caps on ownership, even for Oregon residents and otherwise qualified owners. So how does that residency requirement work? Well, first, let's talk about what resident means under Oregon law. There's a definition at a statute called ORS 316.027. I'll say that again so you can go type it and look it up. ORS 316.027. Your eyes would kind of gloss over if I read it for you line and verse, but the basic requirement there is a resident is somebody who's domiciled in the state. Domiciled means you maintain a permanent place of abode here and not elsewhere, and you're here at least 30 days a year, okay? You can also not be domiciled here, but maintain a permanent place of abode here and spend at least 200 days a year here. So that's the other way to do it. And that's the core of it. There's all kinds of exceptions in the statute and clarifications related to spouses and armed forces members, et cetera. But that's the definition in a nutshell. So how does it apply? Well, it depends on what you want to do here. If you want to be a facilitator, we've been talking a lot about facilitators, or a licensed trip sitter, as I sometimes call it. That's a license that's personal only to you, and it's a clean-cut analysis. You're a resident and you qualify, or you're not a resident and you don't qualify, period. If you want to own a licensed business, like a service center, manufacturing center, lab, then there's some nuance, right? There's what Measure 109 calls this a direct owner. There's a direct owner concept. And the requirement here is that at least 50% of the ownership group must be held by one or more Oregon residents. So that means that you can own a minority interest in one of these businesses if you are not from Oregon. You could be from California and own 49% of one of these. You could be from Michigan. You could be from Mars. It doesn't really matter, right? But you have to find a 50% majority or 51% majority Oregon owner. Now, do I expect to draw up some very interesting business structures to deal with the residency stricture? Absolutely. You're going to see minority owners with call options and other mechanisms to spring into majority positions once these minority owners become residents, or once the residency requirement sunsets, which is in 2025, 2 years from program start. There's just going to be a lot of business creativity here, and people pushing the rules, trying to get interpretations from OHA, stuff like that. It just works like that. I've always hated residency requirements for a host of reasons. The primary reason is that sort of a crude 50% ownership stricture doesn't really address how businesses work or can work. When you own part of an LLC or a corporation, there's kind of a complement of rights that attach to your ownership. One is economic rights and one is voting rights. So residency requirements which restrict ownership don't necessarily affect voting or control by their plain language, right? In other words, an Oregon resident could own more than 50% of one of these psilocybin businesses. Heck, they could own 90% of it, but have very little control over the business, depending on how the governance agreements are drawn. I don't know that's the intent of the rulemaking, but the rules are so simple. Someone who owns less than 50% of a business could also have an outsized right to allocations of profit and loss in the business. I don't think that's probably the intent of a rule, but it also doesn't cut against the plain language of a rule. So it gets kind of complicated and goofy, and I don't want to get too much more into it for purposes of what we're doing, but there's going to be a lot of play in this stuff. Another issue with residency requirements are odd fit for companies capitalized mostly with debt, right? Convertible debt, which is a hybrid equity instrument where the lender may not necessarily own part of the business, but may be able to pull profits out of the business or become an owner on any number of triggers. If it's anything like what we saw with cannabis, there are going to be all kinds of ham-handed silent partner and hidden ownership structures that people also come up with on their own. So just tread carefully there, I guess. The other issue related to ownership restrictions isn't really residency related, but it's a cap on the amount of licensed businesses somebody can own. So Section 21 of Measure 109 provides that an individual can hold a financial interest, and that's a term of art, in only one licensed manufacturer and no more than 5 service centers. So that, it's anti-monopoly stuff, basically. The term financial interest is not defined. That's a job for OHA. I expect them to take a cue from the cannabis rules there. We'll see. But just know for now that you can't own tons and tons of service centers. You can own part of up to 5. So restrictions on ownership. What else in business? I think one big challenge for people owning these businesses will be banking. I've written about this. Few or no cannabis business or licensees were banked, at least knowingly, by banks back in 2013 and 2014 when I was doing this stuff. That changed a bit with some federal guidance we got called the FinCEN memo, but I don't see anything like that coming for psilocybin businesses anytime soon. I believe that banking will not be available generally to start. It means you're a cash business. It's going to create challenges and perhaps even safety issues. If someone knows you have a pile of cash on site at most times, then you may become a tempting target. There are also more basic administrative issues around running a cash business, like bookkeeping, payroll, vendor pay issues, et cetera, et cetera. The list goes on, but at a high level, banking is going to be hard. Another challenge for these businesses is going to be the amount of tax that they have to pay. Psilocybin manufacturers and service centers are both going to feel the bite of an IRS code section called 280E. It basically, in a nutshell, doesn't allow you to deduct all kinds of normal business taxes from your taxable income. So most businesses in America get to deduct their rent and their payroll and their utilities and on and on and on and on from their taxable revenues. Psilocybin businesses won't, in all or in part, right? And it's going to depend on what kind of business you are. I think manufacturers are going to have it a little better. They may get to categorize some things as cost of goods sold. And I don't want to get into all that here, but it's going to be tricky, and tax planning is going to be important. I think you'll also see service centers try to avail themselves of sort of separate trade or business status. They may try to bifurcate parts of their offerings. They may say, well, over here we have a business that does touch psilocybin and does facilitate sessions and things like that, and yeah, subject to 280E. But over here we do other things, and that's a different business, and that part is treated more normally from a tax perspective. It's hard to say. We're going to have to talk with accountants about some of that stuff and tax attorneys. Finally, I think the licensed facilitators themselves, the professionals that have that license that's personal to them, may be able to take a position that 280E doesn't apply to their earnings, which would be really, really good. But again, I'm going to leave that to tax professionals. So I've kind of talked ownership restrictions, banking, tax. Another big issue I think is going to be siting or locating an Oregon psilocybin business. There are really two things to think about there. The first is, will the government let you be there? And the second is, will somebody sell or lease to you, even if the government will let you be there? One great thing about 109 is it preempts local ordinances, so the program may act uniformly throughout the state. Another great thing is local licensing programs are prohibited, sort of like the disaster we've seen in Portland, city of Portland trying to license cannabis business. That's not going to happen here. But still, cities and counties are allowed to opt out, like Angela said, of allowing psilocybin businesses within their borders entirely. And that's a big deal. That the time to watch is going to be November 8th, 2022 at the local election. Do not go sign a lease in October or November, not knowing whether or not your business is even going to be allowed in this place, in the jurisdiction in the first place. You will see cities and counties opt out, especially east of the Cascades, just like with cannabis. And then when they do stay in and opt in, cities can adopt local time, place, and manner regulations. That's kind of like, when can we be open, and or when can your business be open, and what are the hours, and what are the buffers. I think the measure itself has 1,000-foot buffer from schools and maybe 500 feet in certain cases, depending on the type of school, but local places are able to make those kind of minor ordinance rules. Beyond that, we're running out of time. There are going to be business challenges. Maybe we'll do another webinar someday on this, on raising money. There's going to be stuff on intellectual property. There's going to be insurance issues. I do think these businesses are going to be insurable. Whether courts enforce all those insurance contracts is an open question. I think you'll really want to develop good internal practices to shield yourself from liability. That client intake form is going to be huge. If people write things on it that make them seem like they may be a poor candidate for a session, you'll have to think carefully about, your policies on who you want to serve and how you want to serve them. And I'm just going to leave it there. I know I didn't get to all of what I wanted to get to, but that's fine. I think in closing, we've got a couple of questions on religious use in the context of OHA. Mason, do you think you could handle that one question in closing for maybe 2 to 3 minutes? Or is it too tough of a time stricture?
Sure, I'll watch the clock here. There's been increasing sentiment from the public and as well as members of the board and some of its subcommittees that religious practitioners and various accommodations that allow them to ensure that this system is accessible to them have largely been either overlooked or sort of sidelined in the process. Again, Measure 109, it's great in many ways because it's very general, it's very broad and accommodating to many different types of approaches. But if we look at the composition of the board itself, the religious perspective is really not represented there. There are not, as far as I'm aware, people from that background who practice represented. And so there's been growing sentiment that needs to be addressed. And a lot of these rules will potentially burden religious practice involving psilocybin. And religious practice, of course, is protected under RFRA, the Religious Freedom Restoration Act at the federal level, but still it's quite burdensome for religious organizations to ensure that they have that protection. There have been many groups that have petitioned the Drug Enforcement Administration to get that, and they have been unsuccessful. Arguably, there may be a right under the First Amendment free exercise clause as well, but the Supreme Court has not yet acknowledged that. So it's very important in Oregon for this Measure 109 system to be accessible to these groups. In order for that to happen, some of these rules may either need to be relaxed for them, or there may need to be exceptions allowed for them. Some groups, for example, might wish to have a manufacturer license, but they might want the mushrooms, which are a sacrament to them, considered sacred, to be handled in a certain way. And that could be analogous to various rules in food preparation, like kosher or halal preparation of food. But this has really not been addressed yet by OHA. There is a recommendation for a framework for entheogenic practitioners that was approved by the licensing subcommittee and the health equity subcommittee, and that should be going up for full discussion and approval by the board in the next couple meetings. But I do worry about the timing, as this does seem like a fairly urgent matter, considering that time is the clock is ticking. But if the rules ultimately further marginalize these religious practitioners, that could be problematic, both ethically and potentially, legally as well.
That's great, guys. We're over time, and I apologize for that. Really appreciate everybody tuning in. Really appreciate Angela coming from the OHA. Thanks for making yourself available and all the great information you shared today. Thank you, Mason, for taking time out of your busy schedule. Everybody, please know that this has been recorded. We'll probably run it on our blog at some point in the next week or two, and probably write a follow-up post on unanswered questions, because we had a lot of them and couldn't get to all of them. But thanks for tuning in. Take care, everybody. Thank you.
Thank you so much.